The following portion of Daytime is sponsored by Lundy Koch and Martino.
Whether you're looking to make a career move or you're an employer that's seeking new talent, one thing that you should be aware of is the non-compete agreement and some of the recent legislative changes that are associated with it. Joining us to explain is Sam Heller, who specializes in business litigation, among other areas of practice, for Lundy Koch and Martino. Thanks so much for being here.
Thank you for having me.
Yeah, so let's just give a brief overview. What is expected in a traditional non-compete?
So a non-compete is one of several forms of restrictions that an employer and employee can agree to that prohibits or restricts an employee's ability to do certain things after they leave that job.
Okay, so are non-competes absolute? Basically, I'm asking, are there any ways that you can challenge these things through litigation after you leave a job?
Sure. So non-competes and other forms of restrictive covenants are the subject of a lot of litigation and a lot of disputes. And the legislature starts from the premise that any restraint on somebody's ability to work is unlawful. And so for a non-compete to be enforceable, an employer has to be able to demonstrate certain legitimate business interests to show that they have something unique and special beyond just ordinary competition that would be worthy of protection.
So if the career move ended on a not great reason, let's just say someone was terminated, is a non-compete still enforceable if that's the way that it ended?
Part of it comes down to the agreement itself that the employee and the employer have entered into. Sometimes there is language that will discuss what happens to the enforceability of a non-compete, depending on how an employee leaves their job. But ultimately, the ability to restrict someone's activity after they leave a job comes down to whether or not the employer can establish certain legitimate business interests in enforcing that document.
Something to be understood on both sides of it. And I also understand last year in 2024, there were some changes to non-compete laws on a federal level. So where does that stand now? How does that impact us here in Florida?
Nobody really knows right now. As of right now, it's still subject to a number of different federal court litigation and challenges. The important piece is that the state statutes are still in place and they're still subject to enforcement.
Okay, so let's talk about non-solicitation. Explain what exactly that is and how is that viewed here in Florida?
So typical lawyer answer, it depends. And it depends on the agreement because solicitation can mean a lot of different things. Again, we start with what the document says, and then we look at whether or not the way that word is defined, whether or not it is enforceable on the part of the employer.
Okay, when someone is looking over a contract, are there specific things in a non-compete that they should be on the lookout for?
Any employee that is considering signing a non-compete should have that looked at and considered by a lawyer. It's very difficult, even for very experienced lawyers, to be able to give somebody good quality advice about whether or not an agreement is going to be enforceable and under what circumstances. And so everything should be a red flag.
Gotcha, everything. We'll take that as advice. Thank you so much, Sam. We appreciate having you here today.
Sure, thank you for having me.
Thanks. Every little line matters. All right, if you need more information, you can visit olderlundylaw.com or call 813-254-8998. Daytime will be right back.
The preceding portion of Daytime was sponsored by Lundy Koch and Martino.